You have to be honest about the case, because a general mindset of the client always is that there was so much wrong which has happened to him. So, which may not be the case when it comes to the law. Law may have a different perspective, the case may not be as good as what the clients think. So, you have to give them a clear picture.
Hello and welcome to Superlawyer YouTube channel. Today we have with us Adv.Nitish Bagri sir, who is the founding and managing partner of NBA Legal Consultants, an avid litigator. He is an arbitrator as well. He has done his law degree from Bharati Vidyapeeth. And for individuals and startups to corporates and NGOs, he has worked for almost everyone. His inclination is mostly towards civil, criminal, corporate, consumer, family, property, and labor laws, among few others. Welcome, sir, and thank you so much for agreeing to meet with us and share your life's journey with our learners at Super Lawyers.
Thank you. Thank you so much, Divya, for inviting me to your YouTube channel. My warmest of greetings to the complete team of Super Lawyer for inviting me over this session. It is great to connect. Thank you so much. Thank you so much.
Let me start, sir,
Yes.
with the most important question for us is to understand your experience at the bar as well as when you decided to do law. What was there in your mind and how do you reflect on your journey when you see your decade-old experience? What all is there to share?
See, I was a weak-kneed student of science and maths, and I was moderately okay with economics. And at the same time, I was little argumentative and good with logics. Coupled with the fact that I have a history and my family was into legal fraternity, therefore the path of law came naturally. So I was intrigued by the procedures and day-to-day hearings which I got to know in my early age. So that is why I chose the path of law. I joined Bharati Vidyapeeth Law College in Pune in 2006 under the mentorship of the then principal late Mr. Mukund Chadha and HOD Mrs. Ujjwala Bindale ma'am, who had immense love and affection over me during my college days. They had given the opportunity to me to appear and participate in moot court competitions both at national and international level. And that gave me a sense of belonging in the field of law as well as to choose specifically litigation as my career path. And thanks to my internship in AZB and with senior advocate Mr. P.P. Rao, among others, which gave a sense of belonging that I want to do litigation, particularly in field of law, as my career path. They'll help me choose litigation as my career. So that is probably the way I entered into this profession. And God has been kind over me for the last decade, as you said. It has been a very good ride in the profession.
Amazing. So the path was set for you. You just had to decide when to start this.
I
Amazing.
would say that it is a roller coaster ride on a daily basis. I won't say that it was a set path because every person has its own way of looking into the field of law, and it has its ups and downs. It has its pros and cons. But certainly, it is for me one of the most interesting field which I could have chosen as my profession.
Amazing, amazing to know that. So, having worked with so many prominent advocates, to name a few, Mr. Virender Lodha, senior advocate, and Mr. Sajjan Singh, what were some of the most important lessons that you feel should be shared with the learners during your formative years that involve this litigation for government corporations? Because you are two in clients who are doing that. What prompted all this? Our learners would love to know.
When I graduated in 2011 from the college, I joined the chambers of Mr. Sajjan Singh Rajpurohit at Jodhpur. It was one of the most illustrative civil law chambers at Jodhpur. And having joined his chambers, he has given me immense opportunity to argue, appear, draft, and deal with the clients on the civil side. Very interestingly, 5 days into joining the chamber, he had given me opportunity to argue an admission with stay matter belonging to a real estate issue, a writ petition before the single bench of the High Court. So that was the kind of freedom and the confidence my seniors had given me to argue those kind of matters. For 2 years, I worked with Mr. Sajjan Singh Ji Rajpurohit at Jodhpur. Thereafter, I shifted from Jodhpur to Jaipur and joined chambers of Mr. Virendra Luda, senior advocate at Rajasthan High Court, Jaipur. The chambers basically dealt on the constitutional and the service side, constitutional, civil, and the commercial side of the litigations. He was on the senior panel counsel for many authorities and the corporations. So we were doing service matters, we were doing large stake arbitration matters, and being associated with him and earlier with Mr. Satan Singh has given me four basic principles that is good for being in the profession, that is perseverance, patience, consistency. So these are all the three principles which I followed in this particular career. I had seen them working for 18 hours a day from morning 7 o'clock to night around 11:30 and 12. They are dealing with clients, getting brief, preparing for the next day. And having followed them and closely worked in association with them has given those kind of working atmosphere and allowed me to work with them in that setup. And at primitive stage, it might look that, you're working 18 hours a day. It is a very hardworking profession and a demanding profession. So would you like to continue in that profession or not? But thankfully, working 18 hours a day has helped me to start my own chambers subsequently in 2015 when I got independent. And the hard work which they had made me do at that particular point of time helped me in sourcing the clients for myself. So I am very thankful to my seniors, both Mr. Sajjan Singh Ji Rajpurohit and Mr. Virendra Lodha ji, for making me do all the good work in their chamber.
All the good work, smart work, and hard work that you have put in, and the way you are saying that they used to work 18 hours, being senior advocates also, is in itself,
I
it's a learn.
will quote an incident that when I was working in the chamber of Mr. Virendra Lodha ji, there was a call from a briefing council at 11:30 in the night that there is an urgent brief coming up for admission stay matter and he needs to be briefed. So at 11:40 in the night, the conference was fixed. Sir had called me back in the chamber that we need to be prepared for this matter. The briefing concluded at 12:30 in the night. And 6:30, he was sitting in the chamber, and 6:45 or 7 o'clock in the morning, I was in the chamber preparing for that matter, which was to be argued. In Rajasthan, during summer season, there is a morning time. So morning time, the court starts at 8 o'clock and the ending time is 1:30 depending on courts to courts. So 6 o'clock in the morning, he is sitting in the chamber and we are preparing for the briefs. So that is the kind of hard work he has done, and he has also made me do it. So I'm very thankful to him for all the opportunities he has given me in his chamber.
And I'm pretty sure that you are also providing similar kind of opportunities to your juniors as well, because you are going to be an amazing mentor, as you already have had so many nice and open-minded mentors who have allowed you the freedom to appear in court even after just 5 days of entering the field. It's amazing to learn all these things. During this course of time, you have appeared for so many cases in different variety of legal aspects, especially constitutional laws. Has there been any case which you would like to refer to that has had a bigger impact on you than you would have imagined while you were just starting to prepare, or you may have taken up the case and did not realize that particular intensity that it would impact you for maybe some time at least?
Yes, I remember one such case when I was in the chambers of Mr. Sajjan Singh Ji Rajpurohit at Jodhpur. So we were preparing for a case which was related to land use and change in land use and change in master plan of the city. So at that point of time, it seemed to be just another public interest litigation, which we were one of the parties, and we had to put the best interest of the client in his interest. But subsequently, post a couple of years, that became one of the most landmark judgment of the state of Rajasthan, which specifically laid down that there cannot be a change in land use against the master plan, and if there is a change, it has to be done after following the due process of law. And there were certain guidelines specifically imbibed in relation to the change of land use in the complete state of Rajasthan, and that matter was upheld by the Supreme Court. It is landmark judgment now, Gulab Kothari versus State of Rajasthan.
Wow. Amazing. Would you care to elaborate a little bit on that particular case so that students and learners can also understand the impact of that particular case?
So it was a public interest litigation instituted at Jodhpur in relation to the illegal use of certain land or change in land use of a particular area. There was an allegation that it cannot be done against the master plan as well as the procedure was not correctly followed. So the court took a bigger picture and stated that this problem is faced by the complete state of Rajasthan, and we will consider the whole issue not particularly for this land but across the borders of state of Rajasthan. And subsequently, after numerous hearings, it was held that the land use cannot be changed and master plan cannot be simply changed by a stroke of pen. A due process of law has to be followed. So that is one part of the judgment. It shaped the real estate industry post its judgments, because earlier what used to happen was that on a small street, commercial buildings were built. But over the time, impact of that judgment was that there were certain guidelines that commercial establishment will come up on, say, 80 feet and 100 feet or 200 feet of road. So that is the impact of the judgment.
Wow, amazing judgment. After working with the senior advocates for a very short span of 4 years, you started your own practice with NBA legal consultants. What were the challenges that you actually faced when you were transitioning from working in a set environment, then starting your own practice? And if you could share some pointers which people should keep in mind while they want to start their own practice, the kind of hardships that you may have faced, and if that will be
Yes.
okay with you to share.
So when I was working in chambers of both Mr. Sajan Singh Ji Rajpurohit and Mr. Viren Loda, both are encouraged to take an independent briefs other than the office brief, so that you start working independently and dealing with the clients independently. So in 2015, when I took a decision to start my own chambers and got independent from the offices, the first transition which I felt it was necessary as an independent litigator is when you are working under a mentorship, the work is already there in the office. So you have to research or draft and assist your senior in the chamber or argue the matter in the high court or the concerned court. But when you have your independent practice, the first thing is how would you get clients? How would you retain clients? How would you justify your work and fees when you are getting a work? And obviously, when you feel from the client's perspective, having trust or faith on an independent lawyer with a 2 years, 3 years experience is little difficult because somebody's property, somebody's service career, if there is a criminal case, then somebody's life is at stake. So that trust has to be built. And transitioning, the most important factor is that you need to retain clients and give them appropriate results. With the facts that you have to be honest about the case because a general mindset of the client always is that there was so much wrong which has happened to him. So, which may not be the case when it comes to the law. The law may have a different perspective, the case may not be as good as what the clients think. So, you have to give them a clear picture with the fact that you have to give the best performance for the client so that they retain you for their future litigation or future work. Also, when you're working under some mentorship, there is a fixed set of work. So when I used to work in the chambers, I was purely on the issues of litigations, or my core work was litigation. But when I started my independent chambers, we were given non-lit work also, which I had taken up. I had learned from my colleagues at bar, as well as I've learned from my drafting work and old client works that this particular issue has to be dealt with, or some contract work or title work. So when you get independent, you cannot be very sure of what kind of work you'll be getting. So you have to be prepared. You have to be open to all kind of work which you may receive. You probably might not have drafted a criminal complaint in a chamber, but when you get independent, if you have to file an FIR and the police is not registering an FIR, you have to file an istigasa before the concerned magistrate court. So you have to be prepared with that also. So that transitioning happens when you get independent. It has to be taken with open arms, but that is one thing that you should be open to work. You should not restrain yourself to one practice of law.
You have been also very actively involved in dispute resolution. So, in your experience in this particular sector where you have worked with real estate, EPC companies, and all the kind of disputes related to these, across these industries, how do you deliver these innovative solutions and find the best solution for the client as well? Obviously, it depends on how you negotiate the deal. So, if you could care to share some traits for this particular work.
See, every industry have its own difficulties, and every difficulty comes with a problem, and the answer to your problem is different. When you come to EPC companies, they have a bidding dispute, they have contractual disputes which may go for an arbitration or a writ petition in the concerned high court. But when you represent a media company, essentially the disputes are related to either issue of defamation, that some news article is published which may or may not align with the correct facts, or there are labor disputes. There are a lot of labor compliances relating to, say, Journalist Act, Non-Working Journalist Act, Industrial Disputes Act, Cess Act. So those have to be complied with. Then the laborers have legitimate expectations, but the financials of the company cannot fulfill those legitimate expectations. Then the dispute arises. Then you have to put forth the best interest that, see, these are the restrictions. You negotiate with the labor unions, you negotiate with the trade unions, saying that your demand on these aspects are right, but then we have certain restrictions. Let us find a middle way. You won't find probably a good employment environment outside this company. So let us find a middle way to make it work. But if some laborers or workers choose to go for litigation, then accordingly you have to also litigate and put the best interest of the client before the concerned court. And last, when you represent real estate companies, essentially dispute are of three natures. If there is a builder buyer dispute, the appropriate forum is consumer laws, legal services authority, permanent local adalat under the legal services authority, or the Real Estate Act 2017, that is the Real Estate Regulatory Authority. So that covers the builder buyer dispute. But when there is a dispute relating to the landowner, so those essentially are of civil nature. So there will be either a specific performance suit on an arbitration, coupled with the fact that there are criminal litigations also. There are instances of cheating and forgery. So you have to deal with those instances. If there is some dispute with the government in the real estate companies, that may be that a particular land was given to a builder which was in the original land plan, a Charagra land or a land which could not be given to a third party. And that has been allotted, but subsequently a right has been created and some construction has happened. So legitimate expectation of that builder is always there, or the real estate company is always there. So these are the set of litigations or the set of problems each of these industries face. But I feel that before initiating litigation, it is always good to go for a mediation or a arbitration, because litigation in the current times, it is an expensive procedure. There are court fees, there are advocate fees, there is the time consumption, increase inflation is also there, the cost of raw materials also increases. So if there is a middle way out, or if the problem can be resorted or resolved through arbitration or mediation, it should be the first preferences. Even if you have to forego some of the rights which you think is their legitimate right, but if that closes the dispute, a person should opt for it. That is my take on dispute resolution in relation to these industries. But certainly there is no thumb rule that these are the only solution to the problems. As and when the problems come, it has its own set of rules to play. So that is what I suggest, that you should be open to hearing the client's view. You should be open to a recourse which he suggests, but you should also suggest if there is a way out which could avoid litigation and get the business going, then that should be adopted.
Absolutely. It's better to mediate rather than litigate. Mostly, it is what is said. So, in all these kind of cases, which involve very sensitive information also, and there are confidential matters, there is a high level of trust that has to be built, and the client has to be satisfied on a certain level. How do you maintain that balance between the client privacy and legal requirement, and the kind of approach that you take while having these kind of conversations, particularly when there may be a possibility of outcomes not being aligned with their expectations? If you could share some of your pointers where you explain to them the kind of approach which may not be what they are expecting. How do you tackle that, and how do you build trust in that particular environment?
So that is a very good question. See, I believe on the very first instance, client will never share the critical or confidential information. And until unless you have dealt with certain issues of the client in the past, they would not be ready to divulge some confidential secrets of the business. So initially, they would give you litigation which might not involve such complexities. But subsequently, if that client has retained you or has giving you regular work, they have built a confidence on you that whatever information they have shared is in good hands and has not been misused. Thankfully, the Indian legal setup under the Advocates Act 1961 protects the confidential information which is given to the advocate. So, if any information given by the client is a confidential nature, he may not, cause a problem to the client. But at the same time, sometimes what happens is that client is too secretive about some business working or some business agreements or some business arrangements. So that has to be necessarily borne out when you build a confidence in him, that see, whatever information I require it for your well-being. I need to create a case or I need to defend a case. Those informations is required. And at the same time, the usage of the information is restrictive to the litigations only. So you have to keep that professional standards high, so that at least your client is having enough confidence in you to share all such informations, and at the same time maintain that high parallel professional standards of safeguarding his information which has been given or transferred to you in good faith. So that is one thing. But the client has also to be informed that the information is required for creating a defense or creating a case that is necessary. At the same time, a confidence is to be given to him that see, this information is for your well-being. You need not worry that this information will be passed on to the competitors, competitors or maybe misused. So that much confidence has to be built for gaining that information. That is my take on this.
Wow, it's so crystal clear understanding that this is how one should do this transition in between understanding, giving the trust factor and giving them the best solution possible.
I would like to add one more thing, that
Yes, sir.
when the client comes up with a problem, he might come up with a particular mindset. He must have heard that, go for arbitration, this problem would get resolved, or go file a writ petition, or approach a particular forum under a statute, you may get the issues resolved. But then you have to give him a realistic picture that, see, this position might not be very helpful to you in your case because the set of facts on which this litigation will go is different from the set of facts which you may have heard or may have read. So that has to be clearly pointed out to the client. Sometimes what happens is that client has an eagerness to do a litigation or go into a dispute resolution process, but might not be aware of its side effects. So he has to be informed about that also, that see, when you go into these litigations, you must be ready with those counterblast litigations or counterblast adjudicatory process which you may have to face. So you have to be honest in your opinion to the client. It may be harsh, it may be rude, but you have to be honest in your opinion to the client. So at the end of the day, your first opinion which you give to the client after hearing the problem, you may win the issue, you may lose the issue, but that first opinion will always be in his mind. So that is very helpful in your future progress.
The point is to be truthful with the client because they believe in that first statement that you have made and it sticks with them. And absolutely true, sir. So rightly and truthfully said that it should be shared with the client immediately so that they can build that particular trust for which they have come. Over these many years of your experience at the bar and working in both tier 1 and tier 2 cities, where do you see the future of law firms, lawyers, litigating lawyers, especially in tier 2 cities? Because now the work is moving from tier 1 to tier 2. That's what we have seen, the kind of transition. So, what these new entrants can do to be there in their own city and work the best possible career for themselves.
Yes, the transitioning in relation to the work from tier 1 to tier 2 is happening. Earlier, the best of litigation or the best of mind in the legal fraternity was restricted to tier 1 cities. But over the period of time, it has transferred or it has been growing to tier 2 cities as well. You would see some brilliant legal minds as well from the new entrants from the best of law colleges across the country joining in tier 2 cities in the high court, in the good chambers, and the comfort of home is always there, coupled with the fact that there's some good opportunities. These all facts are parallelly linked with the economic growth. So over the period of time, tier 2 cities in India has seen a tremendous growth in terms of business, in terms of real estate, in terms of work problems or work growth, and in terms of the area of tier 2 cities being increased. Also, the IT sector or the manufacturing sectors have gone out of their comfort space of working in the tier 1 cities or specific industrial areas to exploring new industrial areas, which is in and around of tier 2 cities, where the work in relation to the legal field comes to those cities. So, on this particular issue, my take is that tier 2 cities have a brilliant future in the coming times with the best possible legal minds already available in those particular cities. So, these cities will see a very good growth, and the new entrants would have enough work, a diversity of work, I would rather say, for doing it in those tier 2 cities.
So while we are discussing this, I would like to couple two questions. One related to the kind of challenges that you may have gone through while establishing your NBA Legal as a brand. And during working through that tedious time, how have you managed your specifically mental health and your personal life? Because yes, one has to balance all three at the same time. How have you done that?
Establishing NBA Legal was a very enriching experience along with the hard work. So I worked on the private side as well as the government corporation side when I was working in the seniors chamber as well as when I was working independently. So that has helped me in position myself to provide legal services, which includes corporate advisory, which includes litigation, which includes alternate measures of disputes, as well as coupled with the facts of drafting of contracts, title search, due diligences in relation to the solar companies. So the work which I've done has helped me to put in a position where I am today. And the one motto which I've always followed when dealing with any of the client is that I need to be very clear on the facts of the case with my client, that this is my legal opinion. I feel you have a good case or I feel you have a bad case. But be very true to the client. He may choose or he may not choose to litigate or go forward, but that opinion is something which I would like to give him on my initial meetings, that I feel about the case. And over the period of time, I'm always appreciated for that, that this was the first opinion or one of the first opinions which you had given us, and subsequently we have faced that. So that is one thing which I have stick to it, and I would like to stick with it. Second, when you work for multiple corporations or multiple industries, the time consumed is way more. When the time consumed is way more, it certainly affects your personal life. So, as they say in the quote, that take your vacations very seriously. So, take your weekends or take your long vacations very seriously. Go out, travel, or do your hobby activities, whatever you like, but get out of your normal work life to do something which you cannot do in a regular life. So, I have made it a motto that whenever there are vacations or whenever there is a long weekend, I would at least take a day off where I do activities of my choice. I would go out, meet my old friends, travel, do all the hobby activities which I like to do, watch probably a good Netflix movie or series. So that is something which keeps me going and keeps a mental check. And for mental well being, one thing is that you should meet your old friends regularly. So they keep your mental health in order because they have been knowing you for say 15, 20 years. They know what kind of person you are and what kind of probably the work pressure you are dealing with. So that is one method of keeping yourself grounded as well as keeping your mental well-being in check.
Amazing understanding. Yes, we need to be in touch with our old pals so that they keep us in check.
Yes.
Amazing, amazing. Thank you so much. Looking forward to all of this. We would request you to give some advice or the kind of learnings you have till now. Would you like to share with the people who are now aspiring to become either lawyers or they have just started their career, but they're struggling because there are many times that we have seen they do not get the right senior. You were lucky to have those, but there are times when we don't get that one. So how is it that we should keep our approach and keep our attitude also in check, be positive and move ahead and find the right fit for our work? Because not everyone is meant for maybe litigation, not everyone is meant for corporate life as well. So how to decide, if you could give some guiding points or any kind of checklist?
See, there is no strict checklist in my view, but I would say that for the new entrants, there has to be consistency in your work. Whatever work you are getting, either from your mentor or as an independent litigator, there should be consistency in work. Second, you need to be updated with the latest position of law. You cannot stop reading. You have to be updated about what is the position of law, what is the judge's perspective on this particular issue. There are multiple judges hearing rosters, what are their views on a particular subject when I'm talking about litigation. That has to be kept in mind and that has to be consistently followed. There is no alternative to it. And the other aspect is, except for consistency in upgradation of the knowledge, you cannot choose to have a particular set of work in your initial years. You should be open to working for any matter which you may receive. Do not see the volume of this matter is this or the take of this matter is this, but learn about the enriching experience you will get out of that particular issue. So that is one advice I would like to give, that you have to be consistent and you take the work as it comes. Once you do it for a couple of years, you would yourself realize what fits you the best. Would you like to go for into litigation? Would you go for an in-house counsel? Would you like to join a firm? Or would you like to do a freelance work? That will come with experience and with time. On day one, you cannot say that, see, I want this and I need to do this. That is not the case. Only the time will tell and the work you do will tell that how and what kind of work you will do in future.
Absolutely amazing. Thank you so much, sir, for this beautiful, enriching experience. At the end of this particular session, I would request you to give us some golden nuggets for us as well as the new learners and even the seniors, because sometimes, yes, our profession makes us a little overthinkers, I would say, if not very straightforward, but sometimes it's the humbleness which helps us grow.
See, as they say that the word is legal practice. So it is a practice because it's a constant work. it is not a profession. On a daily basis, you are learning. Everybody is learning. Tomorrow, I may face a circumstance I may not have dealt in the past. So that is learning experience for me as well. Consistency is the only thing which I need to give as a golden point, that consistency of work is very important in this field.
Thank you
And
so much, sir, and thank you for agreeing to be with us and share such beautiful thoughts on Choti Diwali. And it's an amazing experience. Hopefully, we'll be learning even more in decades to come. And as our learners should know, that sir is absolutely approachable via LinkedIn, even through super lawyers, or you can outreach him in his chambers as well. As I understand, he is one of the persons who will be sharing his thoughts with the juniors and the new entrants equally, and there will be immense amount of learning. And thank you so much, sir, once again.
thanks, happy Diwali and a great year ahead. It was great talking to you and connecting with your viewers. Wishing you a very happy Diwali again. Thank you so
Thank you,
much.
sir. Thank you so much. Thanks.